Good afternoon, everybody. Thank you for joining us today for our September 2020 CLSA webinar featuring Michael Pallamary. He will be discussing lot line adjustments, boundary line agreements, and certificates of compliance. What's the difference and who cares? Michael Pallamary is the president of Pallamary Associates of La Jolla. He's a founding member of the Land Surveyors Advisory Council on Technical Standards, and he is the owner of www.tiepoints.com, a research site for California land surveyors. So Michael has a lot of content to get through for you all today. We will try to address some questions at the end of the presentation. Feel free to type those into the question box or the chat box, and we will address those as time permits. Thank you, Michael.
Good morning. Let's see here. Good morning, everyone. Can you all see me? I hope. I wanted to send my best wishes to all families in this time of COVID, as we call it. And I just hope everyone is maintaining proper social distancing and that all your families are safe and healthy during this period. I do believe we'll get through this eventually. One of the neat things I think about surveying, it's probably one of the best professions well suited for COVID activity. You're out in the field, it's a healthy time, healthy experience. And so again, just my best of wishes. I'm going to drop my screen and we're going to go through the presentation. And there's a lot of material to cover here. And so this is really a full day seminar. So I'm going to run through a lot of things very quickly, and we can reserve some questions at the very end. And of course, if you have questions that we don't cover or we don't get to, you can submit them through email. I've received a lot of information and questions already, and I'm doing my best to respond to them. So with that, I'm going to move through the presentation. Let's see here. Okay, so the first is the slideshow, the presentation, the PowerPoint. This is a simple outline. And let's see if, forgive me, it's not advancing. God bless this technology. Okay, there we go. So we're going to first talk about the doctrine of agreed boundaries. It's a doctrine. And one of the things that's important is to recognize that the doctrine evolved out of New England. I had the good fortune, frightens me to think about it, 49 years ago, I started surveying up in the New England area. And if anyone has surveyed in New England, you may be familiar with those old deeded descriptions. They were very ambiguous, and oftentimes we were going from the stone wall of Smith to the tree of Jones and on and on and on. Those early surveys were very inaccurate, and so we applied those laws as a means of resolving boundary disputes. And that was a pretty good process, and it was really needed in the New England area particularly. Again, I'm having difficulty with this computer. Please forgive me. My PowerPoint is not advancing.
Try clicking on your screen on the PowerPoint.
Oh, there we go. Okay, thank you. So the courts recognize this doctrine, and probably the most important thing to understand, and a lot of people misunderstand this, is the whole doctrine is intended to secure repose and prevent litigation. I want to emphasize that, is to prevent litigation. All too often, the boundary disputes, of course, end up in litigation. And this is an important point to note. I monitor the forum and other associations in legal journals. One of the things, has been recent discussions on litigation in cases regarding agreed boundaries. People look for them. Well, guess what? There's not many of them. And the reason is, it's the doctrine of agreed boundaries. If parties are in agreement, there's no need to litigate. So you don't often see cases. There's quite a few cases that are out there that are not published. What that means is they're not precedent setting. The courts issue a ruling, but I believe that the reason the court doesn't publish them for purposes of setting a precedent is they really don't want to fool around with this area of law. And it's really important when you think about it. The idea is to give a stability to an agreement. I cannot say this loud enough. This is an agreement. It's an agreement. The parties are solving a controversy, and it tends to prevent litigation. There's really no reason you should be ending up in disputes if you have a complete agreement and, of course, you satisfy the requisite elements under the law. So the principal element is uncertainty. Well, what does that mean? Well, the courts have interpreted it several ways, but my experience, including we did one with 7 parcels of land, and we had conflicting surveys, and there was an 80-foot error in the determination of parcels of land. So there was a number of conflicting surveys. Well, in that case, we determined that there was, in fact, uncertainty. We were able to make that determination because none of the surveyors could agree. Everyone had a reasonable solution. And it's important to understand that it's a two-way street. In order to have an agreement, you need 2 people. I always relate this as analogous to an argument. If someone wants to argue with you, the only way an argument exists is if you engage in the argument. You can't have a one-sided argument. So the doctrine is applied when adjoining owners, 2 or more parties are in agreement, and that's not unreasonable. You can't just be one person, and that's usually where the conflicts come up. If you do see a litigation, it's usually because one says black and the other says white. And so the acceptance and acquiescence equal to the statute of limitations. Now, California, it's 5 years, generally for the adverse doctrines, prescriptive easement, adverse possession, etc. As with an adverse claim, you have a burden of proof. So you have to prove this up. You can't just make a statement. The fact of the matter is you're going to have to prove it. A boundary may be inferred from many years of acceptance of offense as a boundary. There's a great case, I don't have it in front of me, where they talked about the fence, and the court ruled that the fence constituted an agreed boundary. It was up north. A more comprehensive discussion would permit us to discuss that case. But one thing is, as a surveyor, you need to be very, very careful in evaluating evidence. And in California, we have a lot of swimming pools. I call those pools of fences of convenience, or typically with regards to a swimming pool, you have to have a property, enclosed with a fence for life safety, health issues. But a lot of people don't understand what the fence was for. It might have just been put up for convenience, never intended to demarcate a boundary line. Without sufficient evidence is not sufficient grounds to establish apply the doctrine. An assumption is not adequate. You can't just have an assumption. One property owner thinks he or she knows where it is. That's simply not going to work. The doctrine states and tells us that once the line is fixed, it becomes the legal boundary regardless of the accuracy. So this becomes important, very, very important, because the division line does not convey title, and a lot of government agencies do not understand this. I don't intend to harp on government agencies, but the fact of the matter is the impression of lay people is that others, and I don't blame the surveyors employed by a government agency. I think it's the municipal, the politicians, the elected officials. Why the government should not be involved in this is not a conveyance of title. Nothing is being transferred. Nothing is being transferred. The division line per a boundary line agreement, it simply defines it. It does not add to it. That's an important distinction. This is probably the most important thing here. Once the line's established by agreement, everyone is bound to it. You can't say you didn't know or that this didn't happen. I'm sorry, that's simply not going to fly. I've been involved in a couple of cases where we have a party contesting an agreed boundary, and once we've proven it by the predecessor, then that's the end of the discussion. There's a lot of reasons why people make that argument. Time doesn't permit me to hit those. Now, these are my Pallamary's guidelines, right? These are my principles. You may not agree with them. That's fine. Everyone's entitled to an opinion. So as a general rule, and this is general, I don't want anyone to take this personally. As a general rule, most local agencies, counties, and cities do not recognize applicable state laws with regards to private rights. If you talk to them about a boundary line agreement, the first thing they say is, well, you're talking about a boundary line adjustment. No, we're not talking about an adjustment. We're talking about an agreement. I've seen some agencies that have approval forms for a boundary line agreement. I'm sorry, that's absurd. And one of the reasons I believe is because local agencies are reluctant to release control they perceive they may have over private property. It's sort of like a business deal. You're going to sell a truck to your neighbor, you know, a vehicle. Why does the city or the county need to get involved? One of the things they've done, and I've seen this, and I was involved in it personally, and CLSA was, as a matter of fact, is with boundary line agreements, we find that the government uses it as an opportunity to try to exact something out of the parties, environmental parties. Local agencies, as a general rule, and anyone wants to debate me on this, I welcome the invitation. I would love a political debate on this thing, but local agencies are not familiar with the doctrine of agreed boundaries. Why is that? Well, because it's not a government issue. There's no reason for the government to be involved when it's an agreement between parties. It's an agreement between parties. Doesn't involve a local agency. I'm sorry, it falls in the purview of the private property owners. And I guess this is my summary of that position. Rodney Dangerfield, keep your hands off my lot line agreement. It's not yours, it's mine. It's something I am entitled to do under the law with my neighbor. And real quickly, I'm going to cite one particular case. This one goes back to 1908. Young v. Blakeman, and what it tells us, it's to prevent strife in disputes regarding boundaries, and it's to make the title permanent and stable. If it had no greater force than is thus contended, it would be of little benefit, and it would fail to accomplish the purposes which led to its establishment. It doesn't convey title, and I can't say this loud enough. I cannot say this more emphatically. A boundary agreement does not constitute a conflict with the statute of frauds. It is not a transfer of title. Nothing is being conveyed. Nothing is being altered. If there's a lender out there and that lender has an encumbrance upon parcel described in deed A, nothing changes because the asset, the collateral is still the same. It has not changed. So, and as it says here in this published case, it tells us that the lines are fixed, and that's the end of it. So that's a brief overview. There's a lot more to this. Time permitting, we could get into in more detail in finding out what the courts have said about this. Does not transfer title. Can I say that again? Can we have a hoorah? It does not transfer title. End of discussion. Nothing left on the table. So a lot line adjustment, this is where the confusion shows up. And this is really important distinction. These are my general rules. If you know where the line is, it can be adjusted, right? So if we're dealing with a lot line agreement and the parties have agreed and you've satisfied the requisite elements, then you're not adjusting anything. But once you know where the line is, there is no uncertainty, then you can apply the lot line adjustment. In other words, a lot line adjustment is based upon when you know where the line is. A lot line agreement is applied when you don't know where the line is. Consequently, an adjustment, not an agreement, adjustment, agreement. If you're really inclined to pursue this, look up the definitions in the dictionary. An adjustment constitutes a modification of lines, interests, and ownerships. Well, we've got lenders. And lenders have interest in real property. And so what has to happen is the lender has to participate. In many, many agencies across the state of California, the agencies do not impose this condition upon approval of a lot line adjustment. Why, I don't know. But so the fact that an agency does not require a modification to the lender does not escape the reality that the lender needs to participate. As a licensed professional, you have to understand the implications of you applying this particular requirement. The lender has an interest, and that's a senior interest. So if a county approves a lot line adjustment and is silent on this issue, you still have to honor the law. There's some municipalities who make it a condition. There's a current debate on the Surveyors Forum, a discussion about how quickly the deeds need to be filed. And it's interesting because some of them have an immediate turnaround, and there's no uniformity that you have to file deeds within 90 days to effectuate the adjustment. To my knowledge, there is no time frame, but if you don't record the conveyance deeds transferring one parcel to the other, then you're creating a lot of problems. Sometimes, right now we're in good economic times. In bad economic times, lenders can require an appraisal. And the reason they're requiring an appraisal is if there's a diminution of value, if you're taking property from one to another, and if the collateral is the pledged asset that is the property, if you reduce the size of the property, then you've diminished the value of the collateral. So they might require an appraisal. And those appraisals are generally arise during difficult times, bad economic times. Another one is depending on the terms of your note or your paper, a modification of this sort can require an acceleration of the note. What does that mean? Well, it means you have a 30-year note due and payable in 30 years, but a modification of this nature could require the note to be paid off immediately. That can get kind of frightening. So regardless of what the municipalities or anyone else tells you is going on, you need to recognize that this is something that you're responsible for. With regards to lenders, you have to understand if you do a modification of a property and you don't engage the lender, there was a case in the East County area of San Diego. I'll do my best to describe it succinctly, but you'll get the picture. You have two pieces of land side by side. Let's just say they're both 200 feet deep and they're both equal sized rectangles, similar areas, 100 feet wide, 200 feet deep. The one on the left, or the west side, offers to sell his backyard to the guy on the right because the guy on the right wants to put in a swimming pool. So he says to his, this is a true story. So the fellow on the left or the west says, hey, Tom, you can buy my backyard for your swimming pool and I'll sell it to you for $100,000. And so fellow to the right says, that's such a good deal. They record a deed. He transfers the $100,000. The guy on the left or the west transfers the $100,000 to the guy on the right. And guess what he does? Takes the money and runs. He's gone. He left. He left property, left everything behind. Well, property is going into foreclosure because the guy took all the money and ran, and the adjustment came up, and the fellow to the right had claimed that he owned the property to the left. Well, the property to the left, the lender said, wait a minute, we still have a loan on the backyard. I don't care if your swimming pool is out there. I don't care if you think you bought it. You didn't, because we're the lenders. We are the senior note holder. You cannot extinguish us by a conveyance of this sort. Guess what? Got ugly, wasn't fun, and the property owner to the west had to release and relinquish all of the land that he thought that he had acquired. So that's a pretty sad situation. So again, I'd emphasize the surveyors and others, if you have these, make sure that all of the notes are properly modified. If you fail also, and if you've ever seen this done, the assessor will pick it up. The assessor is not going to recognize the division. They may assign, he or she, the assessor may assign a separate parcel for the area that was intended to be conveyed, but wasn't conveyed. It wasn't conveyed because the lender wasn't involved, and therefore it's a nullity. It has no legal effect. For those of you who deal with these kind of notes, as you may know, depending on what area you are in, these notes can be bundled up in the secondary mortgage market. Most of the time, you'll find these are being serviced out of Texas. So when you try to get these things modified, you ended up dealing with people in Texas who are probably, I don't know how kind I can be, but let's just say that that's their first job. So they're not very supportive, not very sympathetic, and they don't understand things. So when we do these adjustments, we can generally refine our fees to a relatively fixed fee. But with regards to the lenders, it's an open T&M for me. And I don't know what it's going to cost. I don't know how long it's going to take. And also one of the problem is depending upon your client or the neighbor's relationship with his or her lender, if they've been delinquent or they're behind in their payments or they've done something that's made the note holder unhappy, they may not want to cooperate. So I put the burden on the property owner, say, hey, well, here's the deal. I need to get your lender to sign off on this. And the sign off goes this way. The property that's being acquired, that note has to be amended to include the area that's picking up, so that the modification to the note includes the additional area. Conversely, the person who's giving up the property, they have to modify their note in a way of a release, that they no longer have an interest in that portion of the property. I've pointed out one of the principal reasons is the foreclosure. The other reason is you're dealing with subdivision map act violations, right? You can't be leasing and subdividing property in that manner without ample consideration. So a lot of people are confused with this. A lot line adjustment is not a subdivision, right? I want to say that again, a lot line adjustment is not a subdivision. The provisions of the exemption occur under 66412D as in Dorothy. Under the subdivision map act, it's a specific exemption. It says no, this is not a subdivision. The local agency can only examine the lot line adjustment to assure that there's conformance with the general plan, specific plans, coastal plans, zoning, and building ordinances, setbacks, etc. Now, the method I use when I do one of these, we prepare the overall exhibit, and it's conceptual. It's a conceptual exhibit. It doesn't need to have a whole lot of information. It shows the boundaries, it shows the areas and the line or the area that's being modified. I take that document, it's a D size sheet, a large sheet, and I provide columns for the property owners to sign off. So it's a statement that says we are the owners of property, parcel A and parcel B. We we agree to the adjustment as shown here on. I capture that immediately as quickly as I can. I put that in a file. I want both parties committed. I'm not going to go forward and then have them arguing later what they intended to do. I get the exhibit, I show the line and any improvements, and the property owners agree to it. That goes in the file. I don't turn it over to the city. I don't give it to anybody. It's in the file to keep everybody honest. And also, if heaven forbid you have a death or some other compromise of health, you've got the intent of the parties memorialized. The city doesn't need to see that, not at this stage. They will eventually. So the other thing is you have to demonstrate compliance with zoning and setbacks. So you'll prepare one of these exhibits, and the exhibit will show building setbacks and all of those things. And those are fair game. Those are fair game because you can't increase the degree of nonconformity. I had one in the county down here where there was a roadway, and the lot line adjustment would have compromised the roadway. Well, okay, so the county denied the application on the basis that the roadway wasn't properly accommodated for. Well, that's a reasonable denial. Now, doesn't mean you're not going to get the adjustment. It means that based on the presented terms, you're going to have a problem. So then you can go ahead and work with the agency to relocate the roadway, as an example. So that's an important distinction. And also it mentions at the bottom here, this is under 66412D, no tentative map, parcel map, or final map shall be required, right? So we see this a lot, and this is important to understand. In San Diego, city of San Diego, there's a wonderful manual, and I know up north in Tuolumne County, they have similar provisions. There's no prohibition against using a parcel map to effectuate a lot line adjustment, right? There's no reason you can't use them. I think it's a superior instrument. Why is that? Well, you can do an alternate lot line adjustment plat where you're basically showing all of the same information, but oftentimes the party wants to see where the corners are. Well, where is the line? Where is the adjustment? So they want monuments set. Well, you can't set monuments under the lot line adjustment plat. You can set monuments under a record of survey. So why I favor the parcel map method is you accomplish everything in one instrument. You have all of the parties signing one document. This is where I referenced earlier. Everyone signs it. You have a recorded parcel map. You impart in all the constructive notice, and you set the monuments in one fell swoop. It's a perfect thing. It's a beautiful thing. Oftentimes when you come back later and you have to do this all over again because you need corners, why not do it in one shot? It's really a great solution. For those of you municipalities that are out there, I would urge you to consider this. I would urge you to look to the wonderful manual that was developed in the city of San Diego as a cooperative document effort by private and public sector. It's a great vehicle. Make life easy, and it's so much cleaner, right? You also have the afforded protections under the MAP Act relative to having a recorded parcel map. The other thing is important, and this is really confusing. You can't require a record of survey. So local agencies like to do that. They can say, well, we want a record of survey. And then we say, well, no, sorry, you're not getting one. Why? Because you can't require it. So this cannot be required. A lot of agencies do it, try to do it. They say, well, give us a record of survey. And so they're going to ask for it. But if it's me, I'm telling you, you're not getting one. And I don't care if there's a local agency ordinance that says a record of survey will be required. You can't, I'm not an attorney. I teach law, but I'm not an attorney. But I will tell you is you can't buck the state law in the same as, a local county can't conflict with federal law. So you have to follow the law. You can't require a record of survey. Once again, by providing the parcel map as an alternative vehicle, you solve that problem. It's a wonderful, wonderful thing. So this is a case I mentioned. This goes back to 1992. I managed this for CLSA back then. CLSA came in as amicus curiae, so we were a friend of the court. And I remember working on this thing with all of the board members of CLSA way back. Good Lord, it was a 1992 decision. It was a very exciting decision down here in San Diego, and where it was a number of parcels along the San Diego River along the Del Mar racetrack. If anyone's been down at the track, gosh, I don't know, we missed it this year. We had hoped that we would have been at the track this year, but that's not happening. So the Subdivision Map Act, this is a reiteration, but these are things that I stated earlier, but that need to be considered, and the appellate court considered when they looked at this. So what happened in the San Diego case, there was, as I recall, there was 9 parcels of land. And so the city was attempting to limit the number of parcels. So they took a rather naive, shall I say, or myopic view that this was only talking about 2 parcels of land. Well, no, not really. So what they were trying to do, what the city was trying to do, these properties were located alongside the San Dieguito River on the east side of Route 5 in Del Mar, the Del Mar side of San Diego, just east of the Del Mar racetrack. And it was really a sensitive, environmentally sensitive land. And it's a beautiful area, by the way. I drive by it frequently. It's a spectacular environmental setting. So what the city was trying to do was, as a condition of approving the lot line adjustment, they attempted to impose conditions. First off, they wanted to deny it because there was 9 parcels. And second, they wanted those environmental exactions as a condition of the adjustment. They said, well, if we agree and if we approve your lot line adjustment, you're going to have to give us 95% of your property because we want it. We want it because there's a bunch of politicians that want to stump the bandstand about how they protected the environment. And that's how these things usually happen. The court recognized this, and they said, well, no, this is a problem. So we got involved, as I said, CLSA, because this had broad implications. So what happened was, and I was involved, I've been actively involved in CLSA since 1979. And in the late 70s and early 80s, I was actively involved in the legislative committee. I participated, as did others, in a lot of this legislation. We had a very active committee under Paul Cuomo. We actually went to Sacramento and lobbied for a lot of this information. And so we came in as amicus, friend of the court, CLSA, and that these additional sentences were added in 1985. And the purpose was, as it says here, this is right out of the court ruling, the appellate decision, these changes were intended to limit local entity review and provide mandatory approval if the local zoning and building ordinances are satisfied. Well, in this case, we had the 9 parcels we were adjusting. And the way to explain these, what they looked like, they were, let's just say simply 9 squares stacked next to each other in a very, squares or rectangles. So you got like blocks, you put blocks down, and some of the parcels had no frontage to the right of way, the street. So what happened was those 9 parcels were all adjusted. They were changed from squares to very long rectangles. And in changing them from the rectangles, every one of them had the minimum legal frontage. Let's say it's 100 feet. So we had, whereas we only had 2 or 3 lots with 100 feet of frontage, by doing the adjustment, we created 9 lots that all had 100 feet of frontage, right? So that was the principal requirement. These were very huge lots. They were undeveloped. That was it. So we satisfied the minimum requirements. All the requirements that existed was lot frontage, zoning, and area. Well, the zoning wasn't changed. So we satisfied everything else. And that's what I said, why this became important and why CLSA took issue with this way back in '85, because we knew this was important. I would tend to say most surveyors would agree that these would be the appropriate things. So the city conceded in the lawsuit. They acknowledged it. It was very difficult fighting with the city of San Diego because it was sort of like thumping them over a head, which we did, that we said you can't condition them. That you can see, you can read the second paragraph. Well, they said, well, you still have to do a subdivision map. And we said, no. It is clear statutory language. This is the court, the appellate court ruling. We cannot accept the city's position. The lot, it's not a subdivision map. And the court also mentioned by any standard it chooses. So basically what you had going on is the city was making things up. The city was fabricating reasons why it was a subdivision. But again, if you go back to 66412D, it was exempt. It was not a subdivision. So any arguments to the contrary fail. Court recognized that. And again, I need to reach out to all the folks that were involved in that effort back in '85, and then also when we filed in as amicus, there was a lot of people contributed to this at CLSA. A lot of people worked very hard on it. So the legislature is little authority for the cities to do this. And this is their language. This is not my language. This is the court language. It says in other words, the agency is not to deal with a lot line adjustment in a way similar to the way it deals with the subdivision. And the city has to honor these. Now, what happens is, I find this, and I don't intend to, impugn any agencies that are out there, but I've been doing this a long time. And one of the problems that I see, and it's an endemic, it's a problem across the state. I work all up and down the state of California. And what happens is we have institutional knowledge, and over time, through attrition and people moving on, you get new people in there that, because of the culture of that particular group, generally driven by a planning department, not surveyors, generally driven by a planning department, emphasis added, not surveyors. They develop these philosophies and perceptions. The problem is those philosophies and perceptions are entirely wrong. But because of the empowerment, dare I say, of planners, and that goes because they're empowered because of political reasons, which I don't have enough time to explain. They're not surveyors. They're not land surveyors. They're not licensed. Land planners don't sign anything. There's no license associated with them. So that is what drives this this corrupt, I'm going to call it a corrupt mentality, an improper mentality. This is another one that became really interesting, is contiguous. One of the arguments that the city made, and that they argued about the definition of contiguous, right? Contiguous. And so the city argued that these 9 parcels were not contiguous. Well, the problem is they were. See, because the city didn't understand that contiguous does not mean they have to touch. A lot of you probably weren't aware of that. Look up the legal definition. Contiguity, contiguous, you don't have to be touching each other. That became something very, very important. So you've seen this. Mike Durkee's mentioned this a couple of times about separation. There's been a number of arguments as whether a roadway constitutes a subdivision. I don't have time to go into that, but contiguous does not mean touching, and adjacent. So that's important. It was the key critical word in this case was adjacent. So let's talk about my favorite subject, certificates of compliance, or shall I say certificates of non-compliance. This is the biggest headache, I think, for any practicing surveyor in the state of California. I work with a lot of Southern California cities, and it's a nightmare. It's a nightmare because as a general rule, they have no clue what their duties are. And as a general rule, they really don't like to follow those rules. When I run into these problems, it's been my experience that when you ask a probing question of a municipality, generally, at least the ones I've dealt with, their response is non-response. They quit returning phone calls. They don't answer emails. They don't answer questions. That seems to be a practice and a policy. I'm not saying this is a general disparagement of all local agencies. I can only tell you what my experience have been over the last, 49, 50 years. There's a lot of rules and provisions under the government code, these areas of relief. This is the government code 6649934. And it's kind of interesting because the issuance of the certificate of compliance, public agencies can deny issuing them, and I applaud them for that, by the way. There's a couple of published cases I think are powerful, and also I agree with them. There's been instances where people have gone in for building permits, and the municipality will deny the building permit, and they deny it because the lot hasn't been proven to be legal. The authority to deny a permit extends to certain classes of people. Now, whether you're dealing with the owner or a vendee, what does that mean? Well, you don't have to be an owner to petition and request a certificate of compliance. How can that be? Well, it's because the law allows it. The law speaks to a vendee. So what happens is, and we do it, we get someone wants to purchase a piece of property, they enter into an escrow or they looking to purchase it, they become a vendee. It's their own due diligence that's motivating them. The seller says, oh, it's a legal parcel, but they either are unwilling to get approval or what. But so as a vendee, you can do that. You can go to the agency and ask for it. This gets very confusing, but basically the general rule, there are exceptions as to when the properties were created, but as a general rule, you can only apply the conditions that were applicable to the division of the property at the time the applicant has acquired his or her interest. We don't have enough time to go through the nuances of this, but the general rule here, you'll have to study this, is if you're seeking a certificate of compliance for a property that was created in 1962, shall we say, the city and the county can't impose contemporary conditions like build a highway and put in streetlights. The improvements, the exactions are conditioned upon the time that the so-called illegal property was created. Now recognize the request for a certificate of compliance doesn't necessarily, or is it not necessarily predicated on the notion that something is illegal. To the contrary, you're just looking to validate that it's a valid piece of land. What this means, the term certificate of compliance, what it means is certificate of compliance, parentheses, with the Subdivision Map Act, and parentheses. You are seeking a certificate that the property complies with the Subdivision Map Act. That's what you're asking for. The issuance of a permit, this is really kind of interesting. So many public agencies, I have a public agency in Southern California who refuses to look at building permits. They simply say, we're not interested. And I say, well, you have to be interested because the law says it. Said you issued a permit for this property 5 years ago. So then they say, well, we're going to revoke that permit. Can you imagine? They said, well, we're going to revoke that 5-year-old building permit because we don't like it. Here's the deal. The law is very clear, and I have all of the legislative history on this. Once a county or city issues a permit, game over. There's nothing else to discuss because people rely on those permits. In one municipality in Southern California, it took me 3 months to convince the city attorney that he had to issue a certificate of compliance. And guess what? The only permit that I provided was a hose bib. The city issued a water development permit for a hose bib. A hose bib was installed and that was it. That was sufficient. The property owner relied on that. So they also define what the real property which has been approved for development. And think about the logic of this, right? You go out there, you get building permits, you're underway, you sell the property, you've relied on it, and everyone else says, how can a major agency come back and declare that your property is illegal when they let you go through the gate? They let you go through the gate. As I said earlier, there are published decisions where agencies have stopped, prohibited the issuance of a building permit because the lot has not been deemed legal. Hooray for the city. They did the right thing. But once you issue the permit and once they go through the gate, game over. You had your chance. City, county, municipal agency, you had your chance. You could have shut it down. You didn't. You let the you let the gate open. You let the horses out of the gate. They're down in the field. You cannot rescind it. But as a general rule, most municipalities don't like that law. And it's interesting. I've gathered up pretty much all of the handouts from the certificate of compliance provisions for pretty much all of the major counties and cities in California. And they never mention this. They never mention this in the handout. They never tell you that this is an option. The handout is silent as to this issue. blows me away. This is the law. And so, as I say, some agencies, I have got one I'm dealing with where they just said, well, we're going to rescind that 5-year-old building permit. Excuse me. So this is another good example. Reliance on a permit, it's defined. We moved into 6649935. This high rise I just use as an example. This was issued permits. So let's say we're topping off a 30-story high-rise condominium, and those condominiums are $1 million bucks each. You're gonna have the city come in 6 months later and say, oops, we made a mistake. We didn't issue those permits correctly. Well, with regards to the certificate of compliance, it's an end game. There's nothing else you can do. The permits were issued. There's nothing that you can do to rescind it, despite the position of some agencies who feel that they can pull these building permits. I asked the question of this one agency. I said, well, how far do you believe your authority goes to withdraw and rescind permits? A month, a week, a year, 10 years? I've got some situations where we've got 10-year-old building permits, right? And they're threatening to rescind a 10-year-old building permit for a property that's been bought and sold a half a dozen times. This is the other provision I mentioned earlier. That's a reiteration when you talk about the vendee. The vendee is going to purchase the property, so he or she can ask these questions. The city or agency can impose a reasonable fee to cover the cost of recording. One of the problems that I have found, and it might be a sign of the times, it's not uncommon for these relatively simple administrative permits to be submitted when you have an unqualified person who doesn't understand it. Probably the biggest problem I've observed is when you get your round of staff comments, it's coming from a person well-intended but has no clue what they're doing. And their first inclination, and this is coming from a public agency, I really can't tell you how many times this has happened, where we get the first round of comments and they start talking about subdivision maps. And so we say, well, yeah, we can do that, but we have building permits. You have to kind of issue these. Oh, no, we don't. And I say, well, actually you do. And they don't understand what a certificate of compliance is. They don't understand what their obligations are. And then you press them, and you got to press them, and maybe 3-4 months later you get to talk to someone, and the person you talk to, it ends up that's their lay opinion. Probably originates from a planner, not a licensed individual, but from a planner who has this erroneous and faulty belief and opinion. This is the restatement again, that the conditions, the exactions that would be imposed on the property, those are the only ones. There's two types of certificates of compliance. Oh, by the way, there's a lot of municipalities that don't like to hear this, but the issuance is mandatory. This is a ministerial process. It's not a discretionary process. A subdivision map is discretionary. A condition of certificate of compliance is not discretionary. I repeat louder. A certificate of compliance is not a discretionary approval. The agency cannot exercise discretion. Emphasis added. It's a ministerial approval. The agency, all it has to do is satisfy that the minimum requirements have been satisfied. That means the building permits. If you have a deed that was created, generally speaking, before March of 1972, that is sufficient grounds to prove up that you have a valid parcel. And again, you can't be imposing all of these crazy conditions. When, let's see here. So this becomes important. There's one of the local cities I work with is in violation of this particular provision of the law, like probably every day of the week, shall we say. And here's what it says. The particular problem we have is we have condominium projects that were created in this Southern California city. And there were thousands of them created. There were thousands of condominiums created. And a lot of these properties were converted and old buildings or what have you. So they're condominiums today. Well, this municipality does not want to issue a certificate of compliance. Well, now that they're on notice, they have a manifest duty to call a public hearing. If they want to do this, the city needs to declare that that is an illegal parcel, and they have to send certified mail. So in the cases I'm working with, I identified about 1,000 condominiums declared illegal by this particular city. So we notified them and we said, okay, here's 1,000 of these. Well, the city that I'm dealing with they're on notice. They have to do something. They can't neglect it, because now that they're aware that there are violations, they have to hold a hearing and a meeting. And the meeting is to permit the property owners to plead their case. Well, this particular agency doesn't want to do that. We were trying to get 1,000 people in front of the municipality, because that is when you plead your case. And if we were to do that, then the political bodies and everyone else would see what's going on, and they're going to probably say, no, that just doesn't make any sense. That kind of sums up my thinking of that topic. We wanted to leave a few minutes for questions. I can ramble on about this for the next month, but I think questions would be more productive. And so I'm going to turn it over to Kim and see if she has any thoughts. We thought maybe we'd gather up a couple.
I do have some questions for you. Let's start with, if an LLA is recorded, but the perfecting deed wasn't, or the record was lost and cannot be produced, is the lot resulting from the LLA legal?
Yeah, this is something that's on the forum. The question is, if there was a conveyance to effectuate it, there's no uniformity here that I'm aware of, and municipalities have different terms and conditions. I would suggest at a minimum, if an agency imposed this as a condition of approval, then if you fail to satisfy the condition, then then you may have lapsed. But alternately, because there is no timeline to my knowledge of when the document should record, when something is lost, it's lost. So you'd want to try to get it re-executed and see what happens. Missing documents are always a problem, and it might need to come down to a form of reformation. What was the intent of the parties? It's not a clean situation. I do think good, solid legislation would help clean that up.
Second question, how do you deal with a county surveyor who will not record an LLA without filing an ROS as part of the process?
The way I normally deal with it, I set an appointment up with the city attorney. If that doesn't work, I'll call a press conference. I'll call the district attorney. I'll contact the state licensing board. I'll do whatever I can. Oftentimes it's an education process, and usually with a large 2x4.
Third question. A city in North San Diego County has been requiring certificates of compliance on lots that have permitted houses constructed on them. The Subdivision Map Act states that properties with permitted structures or structures that did not require a permit at the time of construction shall be deemed lawfully created. Is it legal for cities to require this for lots that are already developed?
Again, I'm not an attorney, but my opinion would be yes. And I usually rely on the tax payments. I believe that the assessment of property taxes on a property owner constitutes a contract with the government. And that, once again, you would want concurrence. You would want to speak with the city attorney or county councils to educate them. But start with the county assessor. You can get a release of the building records and see what their records disclose. And then if that was the case, I've been involved in properties that legitimately didn't have permits, so you get it permitted. But I'd say, there's a way to deal with that.
Going back to the beginning of your presentation, when you were talking about agreements, does the agreement have to have a monetary element to it? And does the agreement run with the land like an estimate?
Yeah, there is no requirement for monetary consideration because remember, nothing is being transferred, nothing is being conveyed. You don't have statutes of fraud issues. There is no conveyance. So if I submit that if you engaged or submitted a consideration, you could arguably be conflicted. You may be actually out of compliance with the application of the agreed doctrine of boundaries, the boundary doctrine, because a consideration suggests something was transferred, and that's not the case. So no, if you start talking, that you want a consideration, I think that you've gone outside the scope of an agreement. The agreement is to maintain the status quo.
With a lot line agreement, can you prepare a parcel map or subdivision map using the agreement as the overall property boundary?
Absolutely, yes, because it's an agreement. And my recommendation when I do these agreements, what I do, and this is, I'm a belts and suspenders kind of a guy. What I tend to do is petition the city or the county for a certificate of compliance on top of it to eliminate any ambiguity. That's usually warm and fuzzy for the lenders. But remember, I can't say this loud enough, the agreement doesn't change anything. If the agreement fixes the division line between lot A and B, nothing's changed. That is the division line.
I have another one for you. Two adjoining owners could not locate their common line, one straight line, even with a competent survey, so they evoke BLA doctrine. They agree that the line circumvents fences and utilities, ending up with a line containing a dozen angle points. Is this permissible?
I don't think so. That becomes a problem for me because I've seen it done, but if you've got to at least subscribe somehow to the intent of the line. The line was intended to be straight. My recommendation in that scenario is fix the line by agreement, and then because you've then ascertained where the line is, then make adjustments for the encroachments subsequent to that. You have to start somewhere. Start with the fixed line by agreement, honor it, and then any deviations from it constitute a conventional easement, encroachment, or possibly a lot line adjustment. And it's an adjustment because you're adjusting a line that you know where it is. There's no longer uncertainty.
Okay, here's another one. Mike, I love the idea of a parcel map for lot line adjustment purposes. This standardizes the entire process. This is the most convoluted process we face due to the fact that every local agency has their own interpretations and rules. How does a parcel map for lot line adjustment get filed and not impose a reassessment fee? And in the current process, you place a note on the lot line adjustment application that this is exempt from reassessment. This could be a huge expense if someone who may be paying very low taxes based on Prop 13 is now assessed to current day rates.
Yeah, the question of assessment and valuation is predicated perhaps on what's being adjusted. Is there an equal, oftentimes it's preferable for a lot of reasons. If an adjustment occurs, you have an equal transfer of areas, unless one party is getting an advantage over the other. And it's a very simple process. You just adopt it by local ordinance. And in Tuolumne County, they have one, and San Diego, it's a great vehicle. You just do it by local ordinance. And the key is to educate the elected officials. Let them know that, the reasons. What would be wonderful is if CLSA mobilized under something like this, because there is a lot of confusion, develop a model and then start educating. We could do a public relations campaign and educate people and then adopt it, and you're over.
Going by parcel map for lot line adjustment, does that not open imposing exactions by the government agency?
No, that's why you cover in the local ordinance. You permit it. I would urge everyone to look at the City of San Diego mapping manual, but it's an alternate vehicle. The parcel map, we're calling it a parcel map, but the condition is to make it, because the lot line adjustment by definition cannot impose conditions, it's implicit that the parcel map being the vehicle of mapping, then you don't impose exactions or conditions. So no, you can't do it. By definition, you can't. And if it's characterized as a lot line adjustment, it's merely a vehicle of convenience, they can't impose conditions. So that defeats the whole purpose of it.
Okay, we have a handful of questions. Let's do a couple more and then we'll have to end it due to time. For a large parcel where single building permit was issued, where there are actually underlying multiple legal lots, can you ask for multiple COCs?
Absolutely. If a structure is, if I understand the question, if the structure sits on top of a multitude of lots, now the structure could be there by a lot tie agreement. I don't know what the vehicle is. There's nothing prohibiting you from building over properties that you own. But if the underlying lots were legally created, they've merely been consolidated for purposes of convenience, not a merger. There's a lot of confusion there. A merger is exclusive under the subdivision map, assuming they have not been merged. And I'm screaming loudly about this versus a consolidation. Yeah, you apply for all those as separate. If you can prove them up individually legal, and the building could have been there for who knows what reasons.
May a COC be issued for a property if, for example, a small portion of the property has been conveyed away?
Well, it depends on how it was conveyed away. The answer is yes, but assuming that the conveyance occurred through some legal mechanism, did you sell it legally? I don't know. The question is, if it was a conveyance, a release of some sort, was it done appropriately? Was it done by map, or when was it done? There's a lot of variables there, but as a general answer, sure, you could do that. I'm just, that it's assuming that the parcel that was conveyed out was done in accordance with appropriate mechanisms. And if it wasn't, then you can cure that perhaps with a separate COC. And a COC can be issued for multiple parcels. It's not limited to 2 or 3.
Let's make this the last one and then we'll wrap it up. When using a parcel map for LLA, is your parcel map subject? Oh, somebody typed in a new question and I lost my spot. Oh, here we go. When using a parcel map for lot line adjustment, is your parcel map subject to conditions of approval?
No, that was the previous question. There was a similarity to it. Yeah, by definition, it's exempt under 66412D.
Great. All right, I think that's all we have time for today. Michael, thank you so much for your time. That was a lot of information in a short amount of time. Just as a note to our attendees today, we'll send you a link to the recording so you can go back and revisit. I know there was a lot of information in those PowerPoints, and I know you guys are anxious to review all of that stuff. So thank you so much. Happy Friday. I hope you all have a great weekend.
Be safe, everyone.
Thank you.
Thank you for the help.